Family court is tough. It's emotionally draining. It's stressful. But imagine this. You're fighting for your child's best interests, and suddenly you're slapped with criminal charges. It feels like a nightmare. You're accused of things you didn't do. The charges feel like retaliation for simply being a vocal parent. Sadly, this scenario is a reality for many parents. The family court system is supposed to protect children, but sometimes it can be used as a weapon against parents. False accusations, exaggerated claims, these tactics can be used to silence parents and gain an advantage in custody battles. It's a heartbreaking situation, but there is hope. There's a legal lifeline for parents facing these unfair charges, a landmark case called Georgia v. Rachel. This case, combined with a powerful legal tool known as 28 U.S.C. Section 1443, can be a game-changer for parents facing retaliation in family court. These legal tools can help you fight back and protect your rights. Remember, you have rights as a parent. You have the right to speak up for your child, and you have the right to a fair fight in court. Don't let anyone silence you or intimidate you. In 1966, the Supreme Court heard a case that would change the landscape of civil rights law. The case involved African-American civil rights activists facing charges in a Georgia court. The activists argued that these charges were racially motivated. They claimed the state court was biased against them. They sought to move their case to federal court. The Supreme Court agreed. The court recognized that when someone's fundamental rights are at stake, a fair trial in state court might be impossible. This landmark decision affirmed the right to remove a case to federal court when a person's civil rights are threatened. But here's why it is so important for parents. Its principles extend far beyond racial discrimination. They apply to any situation where a person's federally protected rights are at risk. This includes the rights of parents in family court, the right to free speech, the right to due process, the right to parent your child without undue interference. These are all fundamental rights protected by the Constitution, and if these rights are being violated in family court, provides a pathway to seek justice in federal court. So, how can parents actually use to protect themselves? That's where 28 U.S.C. Section 1443 comes in. This federal law provides the mechanism for moving a case from state court to federal court. Think of it as your ticket to federal court. But like any ticket, there are specific requirements you need to meet. You can't just move your case because you're unhappy with the state court judge. Here's the gist of Section 1443. You need to prove two things. First, you must demonstrate that the right being violated is a specific federal right designed to protect equal civil rights. This could include your First Amendment right to free speech, your 14th Amendment right to due process, or other federally protected rights. Second, you need to show that the state court is either unable or unwilling to enforce this federal right. This is where strong evidence is crucial. You need to prove that the state court is biased, prejudiced, or simply incapable of providing you with a fair shake. Navigating the complexities of Section 1443 can be challenging. It's not a DIY project. You need a skilled legal guide. An experienced attorney who understands the nuances of federal court removal can be your greatest ally in this battle. Section 4. Fighting back against retaliation. How Georgia v. Rachel protects parents. Let's be clear. Georgia v. Rachel and Section 1443 are not get-out-of-jail-free cards. They don't give you a free pass to avoid legitimate legal consequences. But they do provide a shield against injustice. Imagine this. You're a mother fighting for custody of your child. You believe your ex-partner is unfit, and you raise concerns in court. Suddenly you're hit with a restraining order based on flimsy allegations. Or you're accused of parental alienation because you dared to speak out. These types of actions can be incredibly intimidating. They can make you question whether it's even worth fighting for your child. But here's where Georgia v. Rachel comes in. If you can demonstrate that these charges are retaliatory, that they're designed to silence you and punish you for exercising your parental rights, you might have grounds for removal to federal court. The key is to show a pattern of behavior. Document everything, every instance of intimidation, every baseless allegation, every attempt to silence your voice. This documentation is your ammunition in the fight for justice. Section 5. A cautionary tale. When family court turns into a nightmare. Let's look at a hypothetical example to illustrate how this might play out in real life. Meet Sarah. Sarah is a devoted mother embroiled in a bitter custody battle with her ex-husband. She believes her ex-husband is abusive and poses a danger to their children. Sarah gathers evidence to support her claims, medical records, police reports, and eyewitness accounts. She presents this evidence in court, determined to protect her children. But instead of receiving a fair hearing, Sarah finds herself facing a barrage of counter-accusations. Her ex-husband accuses her of parental alienation. He claims she's coaching the children to lie. He even files a police report alleging that Sarah threatened him. These accusations are baseless, designed to discredit Sarah and punish her for speaking out. This is a classic example of how the system can be weaponized against a protective parent. Sarah's case is falling apart in state court. She's facing the very real possibility of losing custody of her children because she dared to speak truth to power. This is where Georgia v. Rachel and Section 1443 offer a glimmer of hope. By demonstrating that her ex-husband's actions are retaliatory and that the state court is failing to protect her rights, Sarah might be able to move her case to federal court. Section 6. Navigating the road to federal court, practical advice for parents. The decision to seek removal to federal court is not one to be taken lightly. It's a complex process and it's not always successful. But if you believe you're facing retaliation and your rights are being violated, it's a path worth exploring with an experienced attorney. Here's some practical advice for parents who find themselves in this situation. 1. Document everything. Keep detailed records of every interaction, every court filing, every instance of alleged misconduct. This documentation is your best defense. 2. Know your rights. Familiarize yourself with your federally protected rights, such as freedom of speech and due process. Understand how these rights apply in the context of family court. 3. Seek legal counsel. Don't try to navigate this process alone. Find an attorney who specializes in federal court litigation and has experience with Section 1443 removals. 4. Build a strong case. Your attorney will help you gather the necessary evidence to support your claim of retaliation and demonstrate the state court's inability or unwillingness to protect your rights. Remember, the burden of proof is on you. You need to present a compelling case that meets the stringent requirements of Section 1443. It's not an easy road, but for parents facing injustice, it can be the path to a fair hearing. Section 7. Leveling the playing field. Why federal court matters. Federal court isn't about getting special treatment, it's about ensuring a level playing field. Federal judges are often perceived as more impartial and less susceptible to local biases or political pressures that can sometimes influence state courts. Federal courts also have a strong track record of upholding civil rights. They're more likely to recognize and protect your fundamental rights as a parent, and they have the power to put a stop to retaliatory actions that undermine the integrity of the judicial process. By moving your case to federal court, you're not just fighting for yourself, you're fighting for all parents who face similar challenges. You're shining a light on a system that can sometimes be unfair and unbalanced, and you're sending a message that retaliation and intimidation have no place in family court. Remember, you are your child's strongest advocate. Don't be afraid to stand up for your rights and fight for what you believe in. Justice may not always be swift or easy, but it's always worth pursuing.